If you're on a visa in the UK right now, hoping to reach settlement, what you're about to hear could change your entire plan. Just days ago, a powerful committee inside the UK Parliament stood up and told the government in plain terms to scrap its 10-year ILR plan before it ever becomes law. This is not a campaign group. This is not a petition. This is the House of Lords, using its full constitutional weight to challenge one of the most controversial immigration policies in decades. And the reasons they've given go far deeper than fairness. They're warning about poverty, about families being torn apart, about a system the government itself doesn't fully understand. Stay with me, because by the end of this video, you'll know exactly what was said, why it matters, and what it could mean for your own route to settlement. Let's start with what actually happened, because the headlines alone don't tell the full story. On June 23, 2026, the House of Lords Justice and Home Affairs Committee published a major report called Settlement, Citizenship, and Integration. This is a House of Lords Select Committee made up of senior peers with the constitutional power to scrutinize government policy and demand a formal response from ministers. And what they published was not a gentle suggestion. It was, in the words of several legal commentators, a sharp rebuke of the government's flagship immigration reform. To understand why this report landed with such force, you need to go back to where this all started. Back in May 2025, the government published a white paper called Restoring Control Over the Immigration System. Buried inside it was a proposal that would go on to dominate immigration headlines for over a year, doubling the standard qualifying period for indefinite leave to remain, or ILR, from 5 years to 10 years. For anyone unfamiliar with the term, ILR is what most people call settlement. It's the status that lets a migrant live, work, and study in the UK permanently, without the constant cycle of visa renewals. It's the bridge between a temporary visa and British citizenship. Then, in September 2025, the Home Secretary at the time, Shabana Mahmood, used her speech at the Labour Party conference to confirm the direction the government wanted to take. By November 2025, the Home Office launched a formal consultation called A Fairer Pathway to Settlement, which ran until February 12, 2026, and received well over 200,000 responses. That consultation didn't just confirm the 10-year baseline. It revealed the policy was far more layered than a simple 5 to 10 change. Under the proposals, most work and family visa holders would face a 10-year route. But workers in what the government calls medium-skilled roles, things like care work, chef roles, welding, and various administrative jobs, could face a 15-year wait. And refugees on the core protection route could be looking at 20 years before they're eligible for settlement, unless they qualify for a separate work and study route still being worked out. On top of that, the consultation proposed attaching a no recourse to public funds condition directly to ILR itself, meaning full access to benefits would only come with British citizenship, not with settlement, for hundreds of thousands of people already partway through their 5-year journey. Perhaps the most alarming detail was this. The government stated it intended these changes to apply to everyone in the country today who has not already received ILR. In other words, retrospectively, to people who started their journey under one set of rules and could now find the goalposts moved while they're already on the pitch. This single point, retrospective application, became the lightning rod for public anger. 2 e-petitions on this topic crossed 100,000 signatures, triggering a Westminster Hall debate back on February 2, 2026. During that debate, the Minister for Migration and Citizenship confirmed the government intended in principle to push ahead with the earned settlement model. But on the question of protecting people already in the system, all he could offer was that transitional arrangements remain under active consultation. No guarantees, no certainty, just a promise to keep thinking about it. That uncertainty is exactly the backdrop against which the House of Lords report landed on June 23rd. So what does the report actually say? Let's break down the headline findings because there are several, and each one matters depending on your situation. First, and most significant for anyone currently on a visa route, the committee does not support extending the baseline qualifying period from 5 years to 10. The report argues that a 10-year wait for work and family routes would make the UK more restrictive than comparable high-income countries, and that anything longer than 10 years would turn Britain into something of an international outlier. Remember, the proposals on the table include 15-year and 20-year routes for certain groups. The Lords are saying don't go there. Second, and this is the part that will matter most to people already mid-journey, the committee describes retrospective application of these changes as, in their words, manifestly unfair and potentially unlawful. Think about what that actually means in practice. Picture someone who arrived in the UK 5 years ago on a skilled worker visa, did everything by the book, paid the fees, passed the checks, built a life, a job, maybe a family, all on the understanding that 5 years of compliance would lead to settlement. Under the proposal as written, that same person could now be told their qualifying period has effectively doubled through no fault of their own, with no change in their behavior, simply because the rules changed underneath them. The Lords are calling this out directly, and they're not mincing words about it. Third, the report raises something most people outside policy circles never even think about: data. The committee found that the UK's migration statistics are, in their own words, woefully inadequate. There is no reliable ongoing record of who actually leaves the country when their visa expires. Exit check publications stopped in 2020, partly due to COVID and partly due to the post-Brexit system overhaul, and they have never properly resumed. That means the Home Office cannot say with confidence how many people are currently in the UK on valid visas, how many have overstayed, or what really happens to migrants after they arrive in terms of jobs, housing, benefits, or integration. The committee's verdict was blunt. They said, and I'm summarizing here, that the most disturbing revelation of the entire inquiry is that nobody actually knows which or how many migrants are in the UK. If you're building an entire policy framework, especially one as consequential as doubling someone's path to settlement, on data this shaky, the Lords are essentially asking, how can you justify any of this with confidence? Fourth, the committee put forward an alternative. Instead of extending the qualifying period itself, they suggested keeping the 5-year route to ILR in place, but separating settlement from access to public funds. Under their proposal, someone could get ILR after 5 years as before, but remain subject to the no recourse to public funds condition until they've either lived in the UK for 10 years or obtained British citizenship. It's a genuinely different way of solving the same political problem the government says it's trying to fix, addressing concerns about new arrivals accessing benefits too quickly, without making hundreds of thousands of people wait twice as long simply to have basic security over their immigration status. Fifth, the report didn't stop at ILR. It also took aim at the wider system. The committee described the UK's immigration rules and nationality legislation as, quote, a farrago, essentially a confused, overcomplicated mess. They called for urgent simplification, for the Windrush Lessons Learned Review recommendations to be fully implemented, and for the Law Commission's remit to be expanded so it can properly untangle the rules. They also flagged that high immigration fees, including application costs and the immigration health surcharge, are pushing some lower-income migrants towards financial hardship, and in the worst cases, risk people falling out of legal status simply because they cannot afford to renew on time. There's something almost ironic in that warning. A system designed to filter out people who might become a burden could end up creating exactly that outcome by making it too expensive for compliant, hardworking people to stay lawfully in the system. Now, here's where it gets politically interesting. This report didn't land in a stable political moment. It was published in the same window as significant uncertainty over UK leadership following Prime Minister Keir Starmer's resignation. The government is required by convention to respond to select committee reports within 2 months. But commentators have already noted this deadline looks shaky, especially since the government's response to a separate, related report from the House of Commons Home Affairs Committee is itself overdue. So even the normal machinery of accountability is currently running behind schedule, adding yet another layer of uncertainty on top of an already uncertain policy. So what does all of this actually mean if you're someone living through this, whether you're on a skilled worker visa, a family visa, the long residence route, the Hong Kong BN-0 route, or any other pathway towards settlement? The most important thing to understand is this: nothing has changed yet. The 5-year route to ILR remains fully valid right now. No new immigration rules have been laid before Parliament implementing any of these proposals. The House of Lords report is influential. It carries real political weight, but it is not binding. The government can accept it, reject it, or take a middle path. Based on the Home Secretary's own comments earlier this year and more recent remarks from Immigration Minister Mike Tapp, the government's working target for implementation is still believed to be autumn 2026, though some reports suggest it could slip into early 2027, particularly given the current political instability. What this report does is apply pressure, significant, high-profile parliamentary pressure, at a moment when the government is already facing scrutiny from multiple directions. It increases the political cost of pushing ahead with retrospective application in particular. It doesn't guarantee a change of course, but it makes an unchanged course harder to defend publicly. If you're currently building towards settlement, here's the practical takeaway. If you are eligible to apply for ILR under the current 5-year rules now, or you're close to becoming eligible, the safest position is generally to move forward under the existing rules rather than wait and see what happens. Waiting carries risk because if transitional protections aren't ultimately included or are weaker than expected, people who delayed could find themselves caught by whatever new framework eventually replaces the current one. If you're earlier in your journey, the key things to track from here are, first, whether the government formally responds to this Lord's report, which is due within 2 months. Second, whether a statement of changes to the immigration rules is laid before Parliament, because that is the actual legal trigger for any of this becoming real. And third, whether any transitional protections are specifically written in for people already in the UK. This story is far from over. We've gone from a white paper to a public consultation with over 200,000 responses, to Westminster Hall debates, to now a formal House of Lords report calling for the entire flagship policy to be scrapped or substantially reworked. The government's response over the next 2 months could be one of the most consequential immigration announcements in years, for better or worse, depending on which side of this debate you're on. I'll be tracking every development on this channel, the moment the government responds, the moment any new immigration rules are laid, and what it actually means in plain English for real people navigating the system. This is exactly the kind of story where getting accurate, current information matters far more than headlines designed to scare you or reassure you. We'll always go straight to the source. That's everything you need to know about the House of Lords pushback against the 10-year ILR plan, what's confirmed, what's still uncertain, and what it could mean for your own path to settlement. If this video helped clear up the confusion around this story, do me a favor and hit that like button. It genuinely helps this channel reach more people who need this information. And if you want to stay ahead of every twist in this story, the consultation response, the statement of changes, the transitional arrangements, before anyone else is covering it, make sure you subscribe to my channel and turn on notifications, because I promise you, this story is not finished yet. Thanks for watching, and I'll see you in the next one.